This is a Right to Remain information video on judicial reviews in immigration, asylum and human rights cases. This is the second of our information videos. They're kind of like mini training sessions via video that we've done. The first was on appeal hearings, and you can find that on our YouTube channel as well. And today's video is on judicial reviews. We're asked quite often to run workshops in real life on judicial reviews, and it's not an area we do currently run workshops on because they're a really technical and complicated area of law, and actually they're really not the right option for lots of people, even though lots of people might be considering them, as you'll find out in this video. We'd better start with the obvious question: what is a judicial review? As always, we recommend having a look at the Right to Remain toolkit at the judicial review section, because we have a lot more information than I'll be covering in this video. And in the toolkit, we describe a judicial review as being a form of court proceeding in which a judge reviews the lawfulness of a decision or action made by a public body. And in asylum, immigration, human rights cases, that public body will usually be the Home Office. It won't always be the Home Office, because you might be challenging, for example, the decision of a court in a judicial review. But for most cases we're talking about, we'll be thinking about the Home Office. So if you're listening to this and actually the decision you're challenging is from the tribunal, just substitute that when we talk about the decision of the Home Office. So the really important thing about judicial reviews is that they're challenging the way the decision was made. They're not actually challenging the decision itself. They're challenging the how rather than the what. And a judicial review is about if you think a decision has been made illegally, irrationally, or unfairly. So it's not about whether you think the Home Office has made the right decision. Of course, you're not going to be thinking that, and a lot of the time they haven't. It's about how have they made that decision? Has the law been correctly applied? Have the right procedures been followed? And this is really important because it's important how you apply and how you argue your case, but it's also really important then for the outcome. If you are successful, which most people aren't, and we'll discuss that, it's very complicated, very difficult, there's lots of different stages. If you get to the final stage, the full hearing, and you win, the court doesn't say to the Home Office, right, you need to grant this person the right to stay in the UK. They just say, you need to remake that decision if they agree with you that it was unlawful, irrational, or unfair. So the Home Office could remake the decision and still refuse your case or the aspect of your case, but have made the decision in the correct way. This is probably also a good point to mention that I actually find it really difficult to say the phrase judicial review. So not only is it a difficult process legally and technically, I can't even really say it properly. So bear with me in this video. So the situations in which you might be considering a judicial review, there's quite a few different situations, but some are more common than others. The most common applications actually that are received, not just that we kind of come across and talk to people about, are when there's no appeal right in a decision. So you may know that when Theresa May was Home Secretary, she took away appeal rights for lots of immigration decisions. And so now currently there's only appeal rights for decisions that are around asylum protection claims and human rights claims and currently EU law claims. So lots of immigration applications, if they're refused, and of course lots are refused, don't have an appeal right. There's a right to an administrative review, and you can find out more about this in the after a refusal section of the toolkit. But this is actually asking the Home Office to review their own decision. Now, it's a different person than who made the decision that reviews the decision, but it's still the same organisation. And the Chief Inspector, Independent Inspector, was looking at decisions in administrative review cases. And when they were first brought in, so around 2014, the success rate for people in the UK making administrative reviews was only 8%, bearing in mind that appeal success rates are about 49, even higher, maybe 55% success rate for the applicant. And then the follow-up report by the inspector showed that the percentage of successful administrative reviews had fallen to below 3%. So you can see that people aren't going to be succeeding very much on these kind of reviews. And so for them, their remedy might have to be looking at a judicial review. Now, while most asylum and human rights claims still have the right of appeal, the Home Office can actually certify asylum or human rights claims if they think they're clearly unfounded. And if they certify your asylum or human rights claim, that means you don't have the right to appeal within the UK. So in those circumstances as well, your legal option will be possibly a judicial review. Another situation that's quite common is if you have submitted further evidence after your appeal rights exhausted, and so you're asking for your evidence to be considered as a fresh claim. And if the Home Office reject this and they don't give you a right of appeal, they say it doesn't meet the fresh claim test. Again, loads more information on the fresh claim section of the toolkit. This happens in about 85% of times that people put in fresh claims. There's no right of appeal, and so you might be judicially reviewing that decision by the Home Office. You might have heard of people applying for a judicial review if they're facing removal or deportation from the UK. They might be seeking an emergency response, which is called an injunction, and we will talk about that very briefly in this video. There's a few other circumstances as well, but they're really infrequent. If you've been detained unlawfully and you're seeking damages, compensation for that, that's also a judicial review. And if you are being told that your asylum claim cannot be heard in the UK and it's going to be transferred to another EU country under the Dublin regulations, we're talking just before Brexit is meant to be happening, so the Dublin regulations might not exist by the time you watch this video, but we'll see. Usually it's a judicial review that is used to challenge that. Although a recent academic report that looked at case files on judicial reviews showed that they're really unusual. So the most kind of common scenarios where you might be at least successfully applying to pass the permission stage for a judicial review are when asylum or human rights claims or other claims have been certified, or there's no appeal right anyway, or if your asylum or human rights further submissions have been rejected. So that rather lengthy explanation might have made you think, well, there's loads of situations in which a judicial review might be what I need to do or what I need to help my friend to do. But actually, a really important thing to think about is whether a judicial review is the right thing for you to do. It's really hard to get legal aid for a judicial review, which I'll talk about in a second. So if you're representing yourself, you're going to be having to try and navigate this incredibly complicated process. You're going to have to pay the fees yourself because you won't have legal aid. If you lose, then you're actually liable for the costs, which means the judge may say you have to pay for the Home Office's legal fees. Now, in reality, it's actually really unusual for people who've tried to judicially review and lost to actually pay those costs, and I don't think there's much effort made to try and get those costs because the people who have to pay them are often destitute, have no money at all. But you will be considered, if you've lost the judicial review, been ordered to pay costs and you haven't paid them, you will be considered as having a litigation debt. And this is a reason that the Home Office can refuse a future application you make in the UK, or if you try and re-enter the UK after leaving, you might be refused entry on that basis. It's a good job you can stop and start audio recordings, because talking about litigation debt just made me have a coughing fit, which seems appropriate. So just to kind of explore this point a bit more, it can seem like if you haven't got an appeal right, or you feel like you're at the end of the line in an asylum, immigration or human rights claim, like judicial review is your only option. And maybe it is your only option, but it doesn't mean it's the right thing to do. It also may not be your only option. It may be that actually looking at other avenues, which we talk about a little bit in the toolkit page on judicial reviews, might be a better use of your time and certainly a better use of your money. So if you haven't been able to get legal aid representation, free legal representation, and you aren't representing yourself, which is incredibly difficult to do, you might be paying a private lawyer to represent you. Now, there's lots of really good private lawyers who will do a really good job. You still have to find the money to pay them. The problem is there's also a lot of not very good private lawyers, and there's really not much motivation for those not very good private lawyers to tell you if you really haven't got a chance. If you're putting in an application for judicial review, which they know has no way of succeeding, either because it just doesn't meet the criteria or because your case itself isn't very strong, they'll just kind of look at it and say, yeah, sure, I'll apply for a judicial review, that'll be, £3,000. The recent academic report, which we've written about on our legal blog, To JR or Not to JR is the name of the legal blog post. There's been a very long academic report that's looked at lots of case files and has also interviewed judges and legal representatives and some people who've been applying for judicial reviews. And the judges and the legal representatives both really despair of the very poor quality of legal representation they have seen by some unscrupulous lawyers. And they can spot instantly that the application, the grounds for judicial review are just copy and paste. They're just copied from somewhere else. They might not even be relevant to the person's case, or they contain information about another case that they've literally been copied and pasted on a computer. There's a bit more sympathy for the kind of standard grounds that circulate, for example, in detention centres, and people submit themselves because they understand that people are desperate and are trying to do this themselves. There's very little sympathy, understandably, for the private lawyers who take money off people to then put in these very poor judicial reviews. Even if they're being argued well, if the case itself hasn't really got a basis for succeeding, they're still taking money off you, and that's poor legal representation. And as the report points out, the only people who benefit from this are the lawyers, because you might be putting in a judicial review to try and stop yourself being removed from the UK, to buy yourself some time, but actually a poor judicial review can be rejected really quite quickly, and the judge may order that there shouldn't be any further applications, will not be a bar to your removal. So actually it could do you a lot more harm than looking at your options or thinking really carefully about how you can actually get a good lawyer to represent you for a judicial review. It's really difficult to get legal aid representation for judicial reviews now. Legal aid's been cut. Legal aid provision for judicial reviews has been restricted specifically. And there's lots of different stages to judicial reviews that we'll go into in a moment. Legal aid lawyers, if they take on a judicial review application, will only receive legal aid funding if the application succeeds at the permission stage. So if you apply for permission for a judicial review and the permission is rejected, is refused, they don't receive any legal aid funding for the work they've done on the case so far. And this is a really big problem because lots of legal aid firms are really struggling to have any money coming in at all and can't afford to take risks when they're not guaranteed the legal aid payment coming in. So if your case isn't very strong, it's quite likely that a legal aid lawyer will say they can't represent you. We've mentioned private lawyers. Some people do represent themselves in judicial reviews, but it's really, really hard. The kind of body called the Judicial Working Group on Litigants and Persons has said that the system actually wasn't designed for this. It was designed on the basis that people would be advised and represented, and it was designed before the legal aid cuts happened. The academic report we mentioned has interviews with people who have done judicial reviews themselves. It interviews someone called Gladstone who says it wasn't a straightforward process at all. There's a strict process that you have to follow, lodging the application itself, serving notice. It's quite long-winded and it isn't as clear-cut or straightforward as one would have thought. It was just a horrible experience. I did all my research. I did put a lot of hours into doing the research. And then he goes on to say, I don't think the judicial review process is actually set up for anybody to challenge the Home Office on their own. So we've given all these warnings, we've said how difficult it is, you decided to go ahead with a judicial review despite this. Maybe you've got a legal aid lawyer representing you, maybe you're paying a private lawyer, maybe you're doing it yourself. If you are going to go ahead with a judicial review application, there's a really important stage you have to go through, and that's called the pre-action stage. So you might hear about a pre-action letter, a letter before claim, or you might even hear people referring to it as PAP, P-A-P, pre-action protocol. And this is a kind of preliminary stage, and you really do have to do this, otherwise you might have the rest of it rejected, or it'd be definitely referred to very negatively if you don't do this. And this is where, before you put the application in for a judicial review, you say to the Home Office, assuming it's the Home Office decision that you're challenging, that this is what you're about to do. I'm about to judicially review you. This is your opportunity, Home Office, to withdraw your decision, correct an error, remake the decision without having to go ahead with the judicial review. And so you need to write a letter where you explain why you think the Home Office has acted unfairly, irrationally, unlawfully, in what way you think they've done this. Say what you want them to do and when you'd like them to do it by, when you'd like them to make the decision by, and then also give a time frame for when you want them to respond to this letter. So there's two different times there. You want them to maybe remake the decision, and you might say within 3 months, but you also want them to respond to this letter, and usually you say within 14 days. You probably won't get a response to the letter, or if you do, it probably won't be a satisfactory response, but you still got to do it. Once you've done your pre-action letter and you want to carry on, you then have to go through the permission stage. So you can't just go ahead with a judicial review, you have to ask for permission for a court to hear your judicial review. And there's more information about the application form and the questions in the form on the Toolkit website section on judicial reviews. Now, most people are refused permission to proceed. You don't tend to have a permission hearing. The judge just tends to look at the documents you've submitted and makes a decision about whether they're going to grant you permission to proceed with the judicial review. And 90% of people are refused permission to proceed on the papers, so without an oral hearing. If your application for permission is refused on the papers, so this is most people, you can apply to renew the decision, which is when you get to have an oral hearing of the permission application. But when the judge was looking at your application on the papers, they may have decided your judicial review was totally without merit. That's the official phrase, totally without merit. If that is what the judge decided, then you don't have the right to renew the decision. So the judge has refused permission to proceed. They've said your case is totally without merit, and that's kind of the end of the line in terms of judicial reviews. There is an option around applying to the Court of Appeal, but that's extremely difficult to do and almost impossible without a lawyer. If you succeed at the permission stage, the judge says, okay, I've looked at your papers and I think we should proceed to hear this judicial review in full. You might find that the Home Office actually withdraw their decision. So you might succeed in the permission stage and then not go on to the full hearing stage because the Home Office say, oh, okay, we will withdraw our decision, we'll remake the decision, because it costs them a lot of time and money to go on to the full hearing. So sometimes they're sensible and decide to withdraw the decision that you are challenging. So if you've been granted permission to proceed to the full hearing, this is great, but there's now loads of things you've got to do. You've got to pay the fee for proceeding with a judicial review. You only have to pay the judicial review fees if you're not being covered by legal aid. And then there's lots of documents you need to submit to the Home Office and to the court, usually the upper tribunal. You can find out more about this on the toolkit. So if you get to the point of a substantive hearing, so that you've been granted permission, the Home Office haven't withdrawn, then you'll have your hearing. This might not be for months after you've applied for judicial review. If you've got a lawyer representing you, it's probably worth pointing out that you actually don't speak during the judicial review hearing at all, which is really quite unusual. So in the appeal hearing, you will be asked to speak. In a judicial review hearing, if you have a lawyer, you actually don't speak. And as we said, the outcomes then, either you are unsuccessful and the decision stands as it was, or if you are successful, the decision will need to be remade. Just finally, a quick note about seeking an emergency judicial review to try and stop a removal from the UK. Again, there's loads more about this on the toolkit section. There's lots of circumstances in which applying for a judicial review won't stop a removal. So, for example, if there's been a previous judicial review or appeal on the same issue within the last 6 months, if your judicial review proceedings are brought during the 3-month removal window, whilst the removal window policy is being used. While I'm recording this, the policy has actually been suspended. If you are facing removal on a charter flight, where there's lots of people being removed on the same flight, then bringing judicial review proceedings is not enough to get you off that flight. You need to get an injunction. So what is an injunction? Well, it's an emergency interim measure. So as we've mentioned, the judicial review hearing might not happen for months and months and months, so that's not good enough if you're facing removal in a couple of days. So in those circumstances, as well as applying for a judicial review, you also fill in a form called Application for Urgent Consideration. And in that, you, or hopefully your lawyer, because again this is very hard to do on your own, argue why you need an injunction to stop the removal happening. And importantly though, you're saying the removal needs to not happen because something else is happening. So for example, there are aspects of your legal case that you need to pursue. Maybe you're waiting for evidence that you know you are going to be able to get, not just kind of vaguely there may be evidence at some point. There's quite specific evidence you are guaranteed to get, but you haven't got it yet. Maybe there's an appointment that you have booked that will be really important for your case. Maybe there's a really important case in someone else's situation that is being decided, and when that is decided, it will have a big impact on you as well. So you say, don't remove me, you stay the removal until the outcome on that case is decided. But it isn't just, don't remove me. It has to be, don't remove me because there is a really important legal process happening that I need to be in the UK to carry on with. So that's it for this video. Obviously that's not everything there is to know about judicial reviews. As we said, they're really complicated. There's a lot of information in the toolkit, and in this recent blog post we wrote about whether or not judicial reviews are a good thing and the kind of challenges, whether it's the right thing for you. Absolutely, for some people it's what stops them being removed, deported from the UK, and that can be a life and death decision. But there may be other things that you can do instead that are actually more effective, especially if you haven't got legal representation. Take a look at the toolkit section, have a read, have a think, and good luck.